This is proof that Mr. Malema has played a vital role in terms of the burial process, and it is supported by his version that he was entitled to be at the cemetery. It also goes to the crux of the state of his mind. The test for intention is subjective. The court must determine what the state of mind of the particular person is. As I have indicated that I would deal with the issues of discrepancies and of the state witnesses, evidence which relate to the issue of the statement, and oral evidence. Firstly, the statement creates the impression that the accused was denied access into Memorial Park Cemetery for the burial of the late Miss Winnie Mandela. Secondly, it creates the impression that they were stopped even if they were part of the convoy. Lastly, the version under cross-examination went from nobody other than the family and the president were allowed to enter in the vehicles. Only accredited vehicles with permits could enter. The accused vehicle had no escort. Accused vehicle was not part of the convoy. Even if the vehicle had a permit, he would not allow it to enter. He contacted VOC to get permission to allow them entry, and General Zulu did and did not give permission. This is, however, not mentioned to determine whether the accused had a right to enter with the vehicle or not. Since I have dealt with this issue of entry in the Section 174 application, this is now mentioning in light of credibility, which the court still has to deal with. I found that the discrepancies have created a belief in the mind of the accused that their right to freedom of movement and to dignity is being infringed upon, which right is being fully protected by our Constitution. This can also not be placed in a comparison of what have transpired prior the convoy arrived. Those people was not part of the people who attended the funeral of the late Miss Winnie Mandela. It was also being dealt with by Ms. Erasmus, a person of the administration section of Memorial Park Cemetery, who is not the senior of Colonel Venter. Those people were more acceptable to understand that the cemetery was closed for a state funeral and it did not affect their rights to have closure or to bury a loved one in dignity. In terms of the two ladies, they were not prevented entry but informed to wait until the family has arrived. The court will just repeat that sentence. The two ladies were basically informed. They were not prevented to enter but informed to wait until the family has entered. So no impression was created that they are not allowed to enter as in the circumstances of the accused. Therefore, in comparison with the accused, who was part of the people who attended the funeral, and Mr. Malema, who played a vital role as per the funeral program at the stadium, that this submission that there was an alternative method to deal with the issues of entry cannot be upheld nor have any weight nor any basis. I understand the state submission saying that these issues could have been dealt with differently, but not all people act in the same manner when faced with a threat or danger. In approaching the matter to say that because the 5 people was being dealt with in a certain way and that the accused could have spoken to the senior of the complainant to gain entry peacefully would be to apply an objective test without considering the subjective approach as per the case of S versus Tutor. In this case, the applicant was convicted of murder and later on appeal released on the grounds that the court has applied the wrong test in assessing the ground of justification. The facts is shortly that the applicant stabbed 2 police officers who was chasing him, whereby one died and the other one critically injured. He was convicted of murder and attempted murder. His defense was that he believed that the people who chased him wanted to rob him. He has informed his sister after the incident, and also the next day went to report the incident at the police station and was then arrested. On appeal, the court found that the subjective test should be applied to determine whether the ground of putative private defense exists. The state of mind of the applicant at the time of the incident should therefore be considered. Now, looking at intention, irrespective of unlawfulness, the accused must also have the intent to accomplish the definitional elements of the offense of assault. Knowing that the conduct is unlawful, or he must foresee the possibility of his conduct comply with the definitional elements of the offense of assault, and therefore being unlawful but nevertheless proceed with it. Differently put, he must know or foresee that the type of action in which he is engaging in is criminally punishable. This brings us to the point in the state submission and the defense reply thereto, that no version from either accused was put to the complainant during their testimony. The submission by the defense is that no version was put to the accused and that their version was not seriously challenged. To be realistic, one must look at the whole of the evidence, including the plea explanation. When a person says, "I act on the ground of justification," then literally he confirms his actions. In this case, the actions refers to the pushing of the complainant. Therefore, it is also not dispute. Therefore, there is no dispute with regards to Exhibit 3. All this evidence is common cause between the state and the defense. It is right law that the test for intention is subjective. So how does the state prove intention? They may do so by way of direct evidence or indirect evidence. One must also take into account that the accused is under no obligation to give evidence or to prove his innocence. In this case, they confirm the act of pushing the accused under the belief of justification and to exclude any intent of assault the complainant. The version of the complainant affirms that he was assaulted by way of pushing, which is confirmed by the video footage and Mr. Gilbert Mapisa's evidence that he saw people pushing each other. Looking at this with the version of the accused, he pushed him and keep on pushing him to make sure that he does not return to stand in front of the vehicle and block it from going in. Our intent was not to assault the complainant, but we wanted to enter the cemetery to pay our last respects to the late Ms. Winnie Mandela, and above all to get closure. As we then pushed him out of the way so that the vehicle may enter. If I also look at the indirect proof of intent, the court must then guard against applying an objective test instead of a subjective test. It is dangerous to argue as per follows. Any normal person who commits an act which the accused have committed would know that it would result in the assault of the complainant. Therefore, the accused acted intentionally. Although I am free to apply general knowledge of human behavior and the motivation of such behavior, I know that I know that I must guard against exclusive considering what a normal, ordinary, or reasonable person would have thought or felt in the given circumstances. I should go further than this and must consider all circumstances of the case. I have to place myself in the position of the accused at the time of the commission of the offense to establish the state of mind of the accused at the moment. For this reason, the state referral to the 5 other incidents cannot be accepted as already indicated. Also, that the state of mind must be inferred from the whole of the evidence. I cannot infer from that whole of the evidence because the inference seek to be drawn is also not consistent with all proven facts of the case. And therefore, it must exclude all reasonable inferences. I accept the one that is seek to be drawn. Therefore, the version of the accused, as I already alluded to, the discrepancies by the state witnesses creates an impression that they are refused entry as a person and will not be part of the mourners of at the cemetery, which in turn have led to their actions. This version stands, and it was not challenged or contradicted in any way. They intend to remove the complainant to gain entry is also reasonably possibly true. The court also look at the whole merits of the case, which is before me. In the case of S versus Souls, the judgment illustrates the dangers of what has been called compartmentalized approach in the assessment of evidence, an approach which separates the evidence before the court into compartments by examining the defense case in isolation from the state's case and vice versa. What must be borne in mind is that the conclusion which is reached, whether to convict or to acquit, must account for all evidence. Some of the evidence may be found to be false, some of it may be found to be unreliable, but none may simply be ignored. Then when looking at the version of the accused, the court does not have to be convinced that every detail of the accused's version is true. If the accused's version is reasonably possibly true, in substance, the court must decide the matter on the acceptance of that version. Of course, it is permissible to test the accused version against the inherent probabilities, but it cannot be rejected merely because it is improbable. It can only be rejected on the basis of inherent improbabilities. If it can be said that the version is so improbable that it cannot be reasonably possibly true. I would also like to refer to the case of S versus Souls once again at paragraph 180 E to G. There is no rule of thumb or formula to apply when it comes to the consideration of the evidence of a witness. The trial judge will weigh its evidence, consider its merits and demerits, or having done so, will decide whether there are any shortcomings or defects or contradictions in his testimony to determine whether he is satisfied that the truth has been told. When there is a conflict of fact between the evidence of the state and that of the accused, the proper approach in the case such as that is for the court to apply its mind not only to the merits and demerits of the case, but also to the probabilities. So one must take into account the state's case has discrepancies which in turn affects the mindset of the accused. There were mourners on the day in question. They have not planned to be stopped by Colonel Johannes Venter. Since the roads to the cemetery was closed and it is, as per the evidence as a whole, impossible to join the convoy, it can then only be, as I have already indicated in the section 174 application, that the accused had a right to be there. I also accept that the accused was not late for the funeral on that day, that they were also behind the BMW X5s depicted on Exhibit 3, and that the delay in the time was caused by the fact that they were stopped by Colonel Johannes Venter. That version and explanation is reasonable and probable in light of the discrepancies. The erroneous belief in the existence of a ground of justification also, the conduct remains therefore unlawful as well. Subjective factors must be considered in deciding whether an act is lawful or not. However, just as it is wrong to say unlawful is consisting of merely objective external factors, it is similarly wrong to place all emphasis on subjective factors and to forget about the objective ones. No grounds of justification can exist in the absence of objective factors, and for this reason the accused conduct then remains unlawful. If they subjectively thinks that there is a ground of justification, whereas in fact there is none. A so-called putative ground of justification is therefore in fact no ground of justification. A putative ground for justification is one that does not legally exist, but which the accused believe to exist. It exists only in the imagination of the accused. They mistakenly believe that their conduct is covered by a ground of justification. This in turn, when one assesses the state's evidence, it will lead the state to believe that the accused is relying on a ground of necessity. I agree with the state. They did not act in necessity, and that the ground of justification cannot be upheld with regards to necessity. Even when I agree that the accused did not act in necessity, one should also clearly understand the evidence is in its totality form. The accused indication that they both believed that they were entitled to enter the cemetery and their obstruction is unjustified. In these circumstances, they lack mens rea because they believe that they were entitled to enter. So they believe that they have acted on the ground of justification to gain entry. In this regard, the court cannot ignore the defense submission based on the evidence before the court, and that both accused believe that they have acted in putative private defense as well. Irrespective of necessity in putative private defense, it is clear that the test for intention, which is the definitional element of the offense of assault, and for putative private defense is subjective. As alluded above, the accused had reason to believe that they acted on a ground of justification, putative private defense. Their version with regards to their intention is clear, as I see no reason not to accept it in light of the discrepancies of the complainant's evidence. This leads the court then to the crux of the state submission, where the defense of justification is a valid defense based on the evidence on the record. This is a question which the court must also answer on the basis of the evidence in its totality. It is right law that there are different types of grounds of justification. Some well-known grounds of justification is private defense, necessity, consent, and official capacity. Defense specifically also referred the court to consider putative private defense. Now, based on all the principles in law concerning justification, it is clear that the court should apply a subjective test and establish the state of mind of the accused at the time of the committal of the offense. In terms of putative defense, the act will remain unlawful, but it will exclude culpability. In this regard, I found that the state of mind of the accused above mentioned and thus affect culpability. Court's finding, I do then find that the action of the accused at first glance appears to be unlawful, but after carefully assessing the evidence, one can never assault any other human being than in gain of an entry. The evidence in its totality also confirms the version of the accused before court. The accused further lack intent to commit the offense of assault in this regard. In this regard, the court finds that even when the court carefully assess the version of the accused, the court finds that the accused version is reasonably possibly true. Therefore, I accept that the defense of justification is to be upheld and that the accused had no intent to assault the complainant based on the evidence which is listed above. Based on the reasons which is listed above, both accused is therefore found not guilty and acquitted of the charge of assault. Judgment is dated for 29th of February. The court has prepared the court once ordered. Court have also, as indicated. I do not believe the machines are working at this stage. I have then also prepared copies of the written judgment of court for purposes of both parties. Ms. Hart, may just approach. The court judgment is also then being listed in marked as Exhibit S. Is the court book available?
No, Your Worship, the court 30 is sitting in another court, Your Worship.
Court 30. It may then be brought. The court is up. The charge sheet and such must be collected from Mr. Reddy's office. Mr. Reddy.
Mr. Reddy's
Office, yes. Thank you. Court adjourned.